Greetings, YouTube. Apparently one Paul Dorr of, let me get this name right, Okayden, Iowa, was denied a permit to carry a concealed weapon by one Sheriff Weber. It seems that Mr. Dorr is an outspoken proponent of First Amendment speech, using letters to the editor, petitions, flyers, and things to get his particular points across in life. He's very effective at this. He's actually agitated a number of people and apparently is quite an annoyance. But you know, that's part of the whole First Amendment process. You know, you seek out people to listen to you. If they're official positions, you know, they often have to listen to you. It's what the First Amendment was for. Free association, freedom of expression, First Amendment is all about. Well, this activity seemed to have annoyed Sheriff Weber of the local county sheriff. So when Mr. Dorr applied for a concealed carry permit, he denied it, saying that he didn't trust him. And it was blatantly based on the fact that Mr. Dorr had annoyed people in an effort to express himself and to exercise his First Amendment rights. Now, the judge ruled the court finds a tsunami, a maelstrom, an avalanche of direct, uncontroverted evidence in Sheriff Weber's own testimony to conclude beyond all doubt that he unquestionably violated the First Amendment rights of at least Paul Dorr. The case also involved Mr. Dorr's son. And not only has the judge issued an order to the sheriff to give this gentleman his concealed carry permit, something that he actually had in the past apparently, so he qualified for all the other criteria of getting a concealed carry permit, but also is going to require the sheriff to take a college-level course in First Amendment rights, which is good because this man took an oath of office. He swore to defend the Constitution, and yet he went out of his way to stomp all over the constitutional rights of one of the citizens under his protection because this citizen annoyed him. As I've said in the past, you have no constitutional right not to be annoyed or offended. That's just one of the risks you have to take in America. People are going to do and say things that you aren't going to like. You have the right to speak out about this, as I am right here. You don't have the right to deny them of access to whatever you have control over because you don't like their speech. At least not if you're an elected official. And if you're in a private arena of the world, you're looking at more than likely getting sued, or at least having protests against your business. Another useful and effective means of expressing oneself with the First Amendment. I'm glad that this particular judge saw this situation being so clear-cut. I think it sends a useful message to law enforcement, both in Iowa and the nation over, that First Amendment rights matter. They're important. You have sworn an oath to defend them, and that means everyone, even the people you don't like, even when you find it annoying or offensive. You must defend people who are championing the rights for gay marriage as much as you can champion the rights of people who are opposing abortion. It says everyone's speech must be viewed as neutral, as of equal value. Now, you have no constitutional right to be listened to in the public sector, maybe, unless but on the street corner. But when you're petitioning the government, officials, things like that, you have the right to speak. You have the right not to have a sheriff walk all over that right. It's pretty clear-cut. This judge agrees with me. He passed down this ruling, and I'm hoping that the sheriff and all of his subordinates take a lesson from this, and next time, maybe they'll base their decisions on, say, the law, and not their own personal opinions.